35 subsection 1 of the Constitution of the Federal Republic of Nigeria as amended, and Article 5, African Charter on Human and People's Rights, Laws of the Federation, 2004. The applicant has the right to dignity of her person and entitled to her personal liberty. 2, the second respondent, then at the anti-cultism unit of the Nigerian police, did arrest the applicant to his office at Road Safety Road, physically assaulted her by beating and pushing her to the ground and matching her with verbal abuses, that her husband, Daniel, is a junior officer and that he would not do anything, denying her access to her family members and solicitors without taking her to court, contrary to Section 34.1 and 35.1 of the Constitution of the Federal Republic of Nigeria as amended. Section 36, subsection 5 of the Constitution of the Federal Republic of Nigeria as amended, presume any person to be innocent until a court of competent jurisdiction declares him guilty. 4, that the act of the second respondent in violation of the applicant's fundamental right, which should be discouraged and restrained by this honorable court. The applicant in her affidavit in support of the application states as follows, that she is Mrs. Miriam Daniel Omaduemoke, and that she is the applicant in this case, that she has fundamental right to personal liberty and dignity of her human person, and presumed to be innocent until the court pronounce otherwise, that she knows as a fact that she did not commit any offense to warrant her arrest, assault, and inhuman treatment meted on her by ASP Silas Oyibo, that she was arrested by the second respondent who works under the first respondent, having not committed any offense under the Nigerian law, that she has never known the second respondent personally, but do speak with him with cell number 08069227780, given to her by Sergeant Gabriel Daniel on activities of contribution, that ASP Silas Oyibo, the second respondent, arrested her in his personal capacity as there was no formal complaint to him against her, that the second respondent seized her phone and denied her communication with her family members. In paragraph 12 of the affidavit, the deponent states that she was beaten by the second respondent until her heart started palpitating, that she was later told by her husband that she became unconscious, that all effort by her husband, who is a police officer, to take her on bail was refused by the second respondent, that it took the effort of the police public relations officer of Bayelsa State's intervention for the deponent to be released on bail, that from that date, she became hypertensive and has to be going to Federal Medical Center, Yanagua, regularly, that she later wrote a petition to the Bayelsa State Commissioner of Police, where it was referred to clearance officer who did nothing, and later the Commissioner of Police transferred the matter to Ex-Court. That Exhibit A is the copy of the complaint the applicant made to the Commissioner of Police. That Exhibit B is the photograph of the assault made on her by the second respondent. That Exhibit C is a copy of her request to the Commissioner of Police Bayelsa State. That Exhibit D is her medical report and the state of her health. That till when she filed this case, she was not charged to court. That so many Nigerians are suffering from this type of police officers who are paid from the taxes Nigerians are paying, that her arrest was unprovoked. Counsel to the applicant also filed a written address where he stated that the application is supported by 26 paragraph affidavit posted by the deponent. In paragraph 20, counsel raised a sole issue for determination, and in arguing the issue raised, he submitted that application of this nature are peculiar and special in nature and should be ordinarily decided on the basis of affidavit and counter affidavit, and cited the case of AfriBank PLC versus Adico, reported in 2009, Federation Weekly Law Report, part 474 at 2026 to 2027, paragraph E to B, that application of this nature are not granted as a matter of course, but on the fact placed and relied upon by the court, and cited the case of Fortis Finance Bank versus Amefula and others, 2021 LPELR 52780, 40 to 41, paragraph F to C, that award of damage is when breach of fundamental right of a citizen has been established as a constitutional issue and damages naturally flowed. The damages in fundamental rights case must be such as the applicant as due to the respondent's unlawful conduct in considering the damages, and cited the case of Iwe versus Frank Chris, Petroleum Limited and others, 2022 LPELR 56695. Council finally urged the court to exercise its discretion in favor of the applicant. The respondent filed a counter affidavit deposed by the second respondent, Oyubo Silas Ogena Qwen, a deputy superintendent of police. The deponent states that he deposed to the affidavit with the authority of the first respondent, that the facts deposed to hereunder are facts within his personal knowledge, that he has seen the applicant's suit, that he admits paragraph 3 of the applicant's affidavits in support, but not to the extent that any of the applicant's fundamental right is being violated, that he denied paragraph 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 21, 23, 24, 25, and 26 of the applicant's affidavit in support, not as stated in the counter as applicant's counter affidavit, that paragraph 4 is not true, and that the truth is that the applicant was never arrested. The deponent denied paragraph 5 of the affidavit in support and states that he invited the applicant through formal means to inquire from her to know why she disappointed him in his contribution when it is time for him to be paid, that in the process there was altercation, which resulted in the applicant using her finger to poke into his eyes, which resulted in him going to hospital for treatment, as can be seen in the medical report, exhibit CP1 and CP2, that the injury became severe, that he has to be referred to specialists as in exhibit APC3. The deponent also denied paragraph 6 and 7 of the affidavit in support and states that there was never a time that the applicant was beaten. In paragraph 13, the deponent as second respondent denied paragraph 8, 9, and 10 of the counter affidavit and states that of the affidavit in support and states that the applicant undermined his status and refused to give him his money without any explanation, that the applicant stopped picking his phone. That is why he invited her to his office, that the applicant conducted herself in a manner likely to cause breach of peace, that the invitation of the applicant to his office is to settle themselves, being fellow Orubo from Delta State, that the applicant assaulted him and she wrote a petition to the first respondent who grieved him and was later given a warning letter, and the matter was settled administratively as in exhibit APC 4 and APC 5, that he never arrested the applicant or seized her phone or other properties at any time, that the applicant did not come to the deponent's office with her husband, that the applicant was never arrested and denied bail by the deponents. The PPRO that the PPRO did not at any time intervene in this matter, that he denied paragraph 17, 18, and 19, and states that the first respondent treated the case administratively, and at the end, he was given warning. That paragraph 20, 21, 22, and 23 are blatant lies, and not true, and are marred by concealment of facts. That CP Okoli settled this dispute and punished the second respondent. That the suit is an affront since the CP since the present CP is new. That the applicant sued a wrong party. That the applicant lacks local standard to institute this case. That this honorable court does not have jurisdiction in respect of Exhibit B. That the case is not within Fundamental Right Enforcement Procedure Rules 2009. That the applicant was never arrested. That the suit is lacking in merit and the court lacks jurisdiction to entertain same. That Exhibit A, B, B2, C, and D has not been evidential value. That Exhibit D is procured by fraud. That the applicant is healthy. That the applicant did not disclose any prima facie case against the respondents. That the first respondent settled this matter and ordered that the case be closed. That his action was provoked due to her failure to pay him his contribution, and when he invited her, she conducted herself in a manner likely to cause breach of peace. Counsel filed a written address where he states that the applicant application was countered by way of counter affidavit by the respondent, that by her action, the applicant is seeking for an order of enforcement of her fundamental rights under Section 34(1) and 35(1) of the Constitution of the Federal Republic of Nigeria, 1999, as amended. That in opposition to the respondent, the respondent filed a 25-paragraph counter affidavit. That the issue raised for determination by the counsel to the respondent is whether the applicant's suit is not incompetent at the first instance from this court, for this court not to exercise discretion. Counsel in their submission urged the court to take notice of Order 2, Rules 1 and 2 of the Fundamental Right Enforcement Procedure Rules 2009, Section 2A of the Public Officers Protection Act, Cap 41, Laws of the Federation 2004 as amended in 2010, Section 98 of the Police Act 2020, Section 46(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended, and submit that the applicant have no local standard to bring this suit and urge the court to so hold. That the applicant husband and the respondent are all police officers, and the applicant is a member of Police Officers' Wife Association, POWA in bracket. That being members of the police family, there is bond. That the applicant and her husband, not his husband, the applicant and her husband, not his husband, as in the written address, cannot institute this action without the consent of the Inspector General of Police. That the matter having been settled cannot be brought before the court, and counsel referred to paragraphs 4, 11, 14, and 4, 11, and 14 of the second respondent's affidavit. That the action amount to double jeopardy. In paragraph 102 of the address, counsel submitted that the action complained of by the applicant took place between June and August 2022, and that by Section 2A of the Public Officers Protection Act 2004 as amended is statute barred, and urged the court to so hold. In paragraph 10203, counsel submitted that the applicant ought not to have sued the second respondent on his personal capacity when the first respondent has not acted contrary to the law as stated in the address. That similarly, the applicant ought not to have sued the first respondent in his official capacity to facilitate settlement between the parties. that there is no cause of action that accrued to the applicant that will give her the right to file this case, and cited Gani Oladeje versus the Inspector General of Police and one another. 2018 LPELR 45141, that unless there is a misuse of power, a member of the police force cannot be sued, and urged the court to so hold. Counsel cited the case of Nwosu versus Imo State Environmental Sanitation Authority, 1990, 2 Nigeria Weekly Law Report, Part 135 at 715. That by Section 46, subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, it is the State High Court that have jurisdiction to adjudicate in this case, and cited the case of Modokulu versus Nkemdilim and others. 1962 All Nigerian Law Report, page 587. Atiobu versus Oka South Local Government Area, 2002, 15 NWLR, Part 791, 653, Court of Appeal. That Section 251R, 251(1)R of the Constitution provide for cases that can be adjudicated by this court, that where the suit does not disclose any cause of action, the option is for the court to strike it out. Counsel cited the case of Noibi versus Ficolati, reported in 1987, 1 Nigerian Weekly Law Report, Part 52, page 619. That cause of action is an entire set of circumstances giving rise to enforceable claim, and cited Ojukwu versus Yaradua, 2009, 12 Nigerian Weekly Law Report, 1158, at pages 7571, 75 to 76. That by Section 214(2)(b) of the Constitution and Section 4, 24, 23, 24, 25, 26, and 29 of the Police Act, 2004, which is pari material to Section 3, 4, 5, 31, 32, 33, 32, 38, 43, and 66 of the Police Establishment Act 2020. Counsel cited Sections 2, 3, 4, 6, 10, and 11 of the Bayelsa State Administration of Criminal Justice Law, 2009. The police is under the statutory and mandatory duty to prevent and detect crime. Counsel also cited the case of Bebeji Oil Allied Produce Limited versus Pancosta Limited, Volume 31 WRN 162, Michelia JCA, at page 198, lines 20 to 23. That by Section 35, subsection 6 of the Constitution, where there is violation of right, the applicant is entitled to compensation and apology, and cited Jim Jata versus Commissioner of Police, River State, where, according to the counsel, it is the court that will consider and determine the amount of compensation to victims. That fundamental rights are placed on higher pedestal, and cited Arulogu versus Commissioner of Police, Lagos State, 2016 LPELR 40190. In 3.3, counsel submits that the declaratory relief of the applicant offend the fundamental right procedure rules, and cited Olisa Abakova versus Director SSS, reported in 1994 6 Nigerian Weekly Law Report, Part 351 at 473. In paragraph 34, counsel submitted that Exhibit CP1 to CP5 in paragraphs 11 and 13 of the counter affidavit countered Exhibit A, B, B1, B2, C, and D of paragraphs 18, 19, 20, and 21 of the applicant's affidavit. Counsel also cited Badejo versus Minister of Education, reported in 1996 8 Nigerian Weekly Law Report, Part 064, 15 at 19:2, and Hassan Lawan and others, versus EFCC 2014 1 Nigeria Weekly Law Report, Part 1389 607 at 613. Counsel again submitted that this is a matter that have been settled through AGR. In 4-0, Counsel submitted that there is no violation of the applicant's fundamental right. Counsel finally submitted that the applicant's suit is incompetent as none of her right was violated. The action is statute barred, and the court has no jurisdiction to grant the relief sought. Applicant filed further and better affidavit where, as deponent, the applicant states that paragraph 1 to 3 are true, that paragraph 4 of the counter affidavit, paragraph 4 and 5 of the counter affidavit is not known to her, that paragraph 6 is false, that paragraph 11 is false, and that if the business was a civil one, she wouldn't have been arrested to the station and she would have not been popped. She would have not had popped the eyes of the second respondent with her fingers, since there are policemen with guns around his office, and that she don't know exhibit CP1 and CP2. That exhibit CP1 to CP4 are clear breach of the applicant's fundamental right, especially the query dated 30th of April 2021 and warning letter, both signed by DCP Ebon Eyibio, PSC, as to the fact that there was breach of applicant's fundamental right. That paragraph 12, 13, 14, 15, 16, 17, 18 to 20 are not true. That if they were query and warning letter, if they were true, the query and the warning letter wouldn't have arisen. In their written address, counsel submitted that the statutory provisions relied upon by the respondent are completely alien and unconnected and has no bearing or nexus with the present case, and urged the court to discountenance with the submission because they are misconceived. That Section 46 of Section 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, read along with Order 11D of the Fundamental, Order 2D of the Fundamental Right Enforcement Procedure Rules, 2009, it is clear that the Federal High Court is the court to be referred to in this case. Counsel referred to the case of Samuel versus Controller of Prisons, Uyo and others, 2013 LPELR 20707, pages 29 to 30, paragraph C to D, Tukur versus Government of Gongola State, 1989, 4 Nigerian Weekly Law Report, Part 117, 517 at 546, paragraph F to J, that in Nigeria Ajib Oil Company Limited versus DEO and others, 2020, LPELR 55726, pages 45 to 46, paragraph D to B, the court states that statute bar limitation does not apply to fundamental right cases, that action of the second respondent cannot be covered by the police, but arising from pure civil dispute, since it relates to contribution which implies that he used his office to infringe on the applicant's right. Counsel urged the court to dismiss the application. In reply, the respondent filed a further and better affidavit where Oyibo silenced the second respondent deposed to as deponent, that he has seen and read the applicant further and better affidavit, that paragraph 3, 4, and 5 of the further and better affidavit are false, that the applicant was not arrested, detained, or investigated, that the deponent peacefully invited the applicant, and that while in his office, the applicant conducted herself in a manner likely to cause breach of peace, that the applicant wrote 2 petitions against the deponent, that paragraph 5 violates rule of evidence without stating the section of the law or the case law, that the paragraph is an admission that the applicant poked the second respondent's eye, that the act of the first respondent in querying the second respondent is to forestall normalcy and amicable settlement between the second respondent and the applicant. That paragraph 12 to 21 of his counter affidavit are all true to the best of his knowledge. That paragraph 7 of the applicant's argument is marred with argument and is defective. The application is malafide. Counsel in their written address in paragraph 03 states that the police are clothed with authority to perform their onerous duties and they are at liberty to perform that duty. That the police are at liberty to exercise this discretion in a manner or form they wish to perform. Sometimes law enforcement agencies may issue invitation to a person with the aim of investigation of certain facts or otherwise allegation against the person, and that such invitation cannot by any stretch amount to violation of fundamental rights of individuals. That Samuel versus Controller of Prison and Tukur versus Gongola, all supra, is to the effect that the applicants have duty to prove their case. The invitation is not arrest, and cited Saraki versus Inspector General of Police, even though there is no citation to it. Counsel states that Section 115 of the Evidence Act 2011 that affidavits should not contain a legal argument, and cited Buhari versus INEC and 4 others, without also producing the citation. Ladoja versus INEC without citation, Abubakar versus Adua without citation. This is elementary even for law school students, that you must not cite a case without citation. I am surprised that even with all our electronic law reports, counsel will be citing cases without their citations. The citation in Buhari versus INEC is 2008 LPELR 814 Supreme Court. Ladroja versus INEC 2009 LPELR 1738 SC. Abubakar versus Adua is 2008 LPELR SC. Counsel also cited Honorable Linda versus Chuba Ekpeazu 2017 LPELR 41920 as per orderly JSC page 52, paragraphs A to E, that this matter having been settled in ADR, applicant has lost her local standard to bring this action. Counsel urged the court to dismiss the suit. When this case came up for hearing on the 18th of January 2023, counsel to the respondent, CSE Ebete, informed the court that they have filed preliminary objection to the suit and they are ready to move the preliminary objection. Same was moved and adopted. The applicant counsel also adopted his counter affidavit to the preliminary objection of the respondents. The preliminary objection was brought under Order 8, Rule 1, 2, and 3 of the Fundamental Rights Enforcement Procedure Rules 2009, Section 98 of the Police Act 2020, and Section 2A of the Public Officers Protection Act, Cap 41, Laws of the Federation as amended in 2010, Section 251 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the inherent jurisdiction of this court. The motion is praying for an order dismissing the applicant's suit for being incompetent and lack of jurisdiction to entertain the suit. B, further order or orders of this court as the court may deem fit to make. The ground for the objection are that the respondents are public officers who are protected by the Public Officers Protection Act 2004 as amended, that the applicant husband is a police officer while the applicant is a wife of a police, that the applicant unlawfully assaulted the second respondent by using her hand to poke as against the word used, chook, which has no ordinary dictionary meaning, the eyes of the second respondent. The applicant has no locus D, that the applicant has no local standard to institute the suit against the Commissioner of Police. It is a reputation of A, that F, that the applicant did not disclose any reasonable cause of action. G, that the suit was brought within the dictate of the Fundamental Rights Rules 2009, hence incompetent, was not brought within the dictates of the Fundamental Rights Enforcement Rules 2009, as such is incompetent, that there is no iota of truth. I, that the applicant was neither arrested nor detained by the first and second respondent. J, that the subject matter in this case is assault, which is not within the contemplation of Section 251, 1, 2, and 3 of the Constitution of the Federal Republic of Nigeria as amended, and Section 7.1 of the Federal High Court Criminal Trial Act 2013. Counsel also filed affidavit in support of the preliminary objection. The affidavit was deposed to by the second respondent, who states that he is a deputy superintendent of police attached currently to traffic division of the Bayelsa State Police Command, that he was sued together with his boss using the word in the affidavit, that himself, Inspector Daniel Omoduemike, and Commissioner of Police are all public officers, that the matter involving police officer and another or a member of police family are governed by the Police Act and are to be settled amicably, that he is deposing this affidavit with the consent of the Commissioner of Police Bayelsa State, that all police officers are being protected by the Police Officers Protection Act, Public Officers Protection Act as amended. In paragraph 8 of the affidavit, the deponent states that the subject matter in this case is monthly contribution of 100,000, which the sons and daughters of Urobo extraction agreed, organized, and embarked upon, and the applicant is the chairperson, refused or failed to pay him his own turn when it is his own turn without just and verifiable cause. That upon her disappointment, that upon his disappointment with her, he sent his boys to invite the applicant to his office at anti-cultism unit to inquire why the applicant refused to pay him. In paragraph 10 of the affidavit, the deponent states that when the applicant came to his office, she boasted that she is a poor woman and her husband is a policeman and has connection in the force more than the second respondent, and used her fingers to poke into the eyes of the second respondent. That from there, he ordered her to be taken out, and she started crying. And he, the deponent, was went to the police hospital to treat himself. That the applicant later wrote a petition to the Commissioner of Police that the invitation does not amount to arrest, that the applicant act is tantamount to assault on a police officer, which is against Police Act, that the deponent was punished when the matter was reported, that he was issued query. In paragraph 15, the deponent states that A, the action is started bad, B, the suit disclosed no reasonable cause of action, C, that the suit was not brought within the provisions of Fundamental Rights Enforcement Protection Procedure Rules 2009, hence is incompetent. D, that there is no iota of truth in the case. E, that the applicant was neither arrested nor detained. F, that the main suit is assault, which this court have no jurisdiction. In paragraph 16, the deponent states that any pronouncement as to compensation and damage on him amount to double jeopardy, since he has been punished administratively by the Commissioner of Police, that the applicant has no local standard to bring this action against the respondents. The plaintiff's case as applicant to the plaintiff's counsel as applicant to the as respondent to the preliminary objection was also filed with a written address. In paragraph 01, counsel submitted that the preliminary objection is challenging the competence of the applicant suit, that the objection is premised on order 2, rules 1 and 2 of rule 1 and 2, order 8, rules 1 and 2 of the Fundamental Rights Enforcement Procedure Rules 2009, section 98 of the Police Act, section 2A of the Public Officers Protection Act 2004, section 46, 1 of the Constitution as amended and under the inherent jurisdiction of this court. In paragraph 04 to 05, counsel raised a lone issue, whether the applicant suit is not incompetent at the first instance for this honorable court not to exercise its discretion. Under paragraph 20 of the written address, counsel submits that based on the sections of the law cited under 01 and the inherent jurisdiction of this court, the applicant has no locus to bring this suit against Commissioner of Police, which has affected the competence of the applicant's suit and urged the court to so hold. In paragraph 201, counsel submitted that as per paragraph 3 of the affidavit in support of the notice of preliminary objection, the applicant husband, Inspector Daniel Omodiomuke, first respondent and the second respondent are police officers, that the applicant is a member of Police Officers' Wife Association, POWA, and that since they are members of police community, their activities are controlled by the Police Act, that the applicant cannot file this suit without the consent of the Inspector General of Police, that the matter having been settled by the Commissioner of Police, the applicant has no local standard to bring this action against the first and the second respondent. That pronouncement of court against the first respondent amount to double jeopardy, that the first respondent on record is Commissioner of Police Bayelsa State. In paragraph 202, counsel submitted that this suit having been filed outside the stipulated 3 months, as in the provision of section 2A of the Public Officers Protection Act, is statute barred. In 203, counsel also raised the question as to whether a member of the Nigerian police can be sued personally for an act done in discharge of his official duty, that the applicant cannot sue the second respondent since he did not act outside the law or abuse his powers, that by settlement done by the first respondent departmentally, no cause of action accrued. Counsel cited Nwosu versus Imo Environmental Sanitation Authority, Supra, and Aremo 2 versus Adekangi. In paragraph 2.04, counsel cited sections 46, 1 and 2 of the 1999 Constitution as amended. Counsel submitted that there is no iota of proof of the allegation by the applicant, hence there is no right of action for the applicant. In paragraph 205, counsel submitted that this court lacks jurisdiction to entertain this case, since what gave rise to the action is monthly contribution of 100,000 by honorable sons and daughters resident in Yanagua, which the applicant is the chairman, that by paragraphs 8, 9, and 10 of the respondent affidavit in support of the notice of preliminary objection, parties are not properly before this court, and cited Modokulu versus Nkemdlem, Supra, and Oka local government, Oka South local government area, 2005-15 Nigeria Weekly Law Report, part 751635. In 30, counsel submitted that when a suit discloses no cause of action against the respondent, the suit should be struck out, and cited Novi versus Picolati, Supra, Ojuku versus Adua, Supra. Counsel submitted by section 214, 2B of the 1999 Constitution as amended, section 4, 23, 24, 25, 28, and 29 of the Police Act, which are in pari materia with sections 3, 4, 5, 31, 32, 38, 43, and 66 of the Nigerian Police Force Establishment Act, and Section 234, 610, and 11 of the Bayelsa State Administration of Criminal Justice Law. The police are empowered to detect and prevent crime. Just as to add here that what this court apply is Administration of Criminal Justice Act 2015. And by the law cited, Bayelsa State adopted the act, but applicable to the state courts, that the applicant assaulted the second respondent by poking her fingers, not choking as stated in the address, into the eyes of the second respondent, as in paragraph 11 to 14 of the respondent's affidavit in support of the preliminary objection. Counsel cited Bebeji Oil Allied Product versus Pancosta Limited, Supra, as per Michelia JSC. In 3.2, counsel submitted that by section 35.6 of the Constitution, what the applicant is entitled to when he or she proves their case is compensation and apology, and cited Jim Jata versus COP, River State. 2013 6 Nigerian Weekly Law Report, part 1350, 225 Supreme Court. Counsel also cited Orugolu versus Commissioner of Police, Lagos State, and others, Olisa Abakova. Counsel submitted that finally the applicant's suit is incompetent since the action is statute barred, and this has robbed this court its jurisdiction to hear them. The applicant filed a counter affidavit of 12 paragraphs proposed to by the applicant herself. In paragraph 2, 3, and 4 of the counter affidavit, the deponent states that she is denying paragraph 2, 3, and 5 of the respondent affidavit in support of preliminary objection, particularly her fundamental right was an issue. In paragraph 6, the deponent states that paragraph 7, 8, 9 are false, and that she was arrested without knowing why till date, that she was not told that the arrest was in respect of contribution, that the second respondent does not owe any amount contributed, that paragraph 10 is false, and that she never conducted herself in a manner to likely cause breach of peace, that she wrote a petition to the first respondent in respect of her fundamental right, that paragraph 12 is false, and she was denied access to her husband and family by the second respondent, that paragraphs 13, 14, 15, 16, and 17 are false, and states that she never assaulted the second respondent, otherwise she will have been charged before the court. Rather, it was the second respondent that was queried and warned. In paragraph 11, the deponent as applicant states that she is not making claim of assault before this court, that is her right that was violated and not her husband, and that this is a personal action. Counsel filed a written address where he states that they are opposing the preliminary objection filed by the respondent, that the statutory provision relied upon by the respondent are alien and unconnected, and has no nexus or bearing with the pending suit before the court, that the entire argument of the counsel is misconceived, and urge the court to discountenance with the same, that section 46(1) of the Constitution read along with order 2, rule 1 and 2 of the Fundamental Rights Enforcement Procedure Rules 2009 is clear that the court conferred with jurisdiction is Federal High Court. Counsel referred to the court to the case of Samuel versus Controller Federal Prisons, Uyo, Akwa Ibom State, 2013 LPELR 20707, pages 29 to 30, paragraph C to D. Chukur versus Gongola, Government of Gongola State, Supra, Nigerian Ajib Oil Company Limited versus Dio Order Supra. That pages 45 to 46 is clear to the effect that the action burden on fundamental right is not statute barred. even if it happened before the commencement of the rules. That the second respondent was queried as a result of his action against the applicant leaves no room for doubt that the action of the second respondent cannot avail him coverage under the Police Act. By affidavit, the second respondent has made it clear. By his affidavit, the second respondent has made it clear that what transpired was not a police duty, but arising from contribution, which implies that the second respondent abused his office, that the authorities cited by the respondent are irrelevant and they do not address the crux of the matter. Counsel to the respondent filed further and better affidavit, and the second respondent as deponent states that as follows, that in paragraph 3, deponent states that paragraph 3 of the counter affidavit is not true, and that in Christian marriage, husband and wife are the same. That first respondent have intervened and settled this matter amicably through ADR. That paragraph 7 and 8 of the applicant's affidavit are false and state as follows, that this court has no jurisdiction over contribution of 100,000 by members of her contribution group, that the applicant fraudulently converted his money by refusing to give him. That refusing to give him his money amount to stealing, and he chose to invite her through informal means to resolve their differences, but the applicant decided to behave otherwise by poking his eyes, which amounts to assault, and he asked his boys to take her away from his office without any form of torture or molestation. That he did not report the assault because of his relationship with the applicant. 7, that the applicant was not arrested, charged, detained, or investigated, or denied access to her family. In paragraph 9, in paragraph 9, the first respondent as the second respondent as deponent states that the parties conceded to amicable settlement, that the applicant decided to be mistaken by bringing up the matter, that the applicant is trying to put something on nothing, that it is the duty of the court to facilitate ADR, that the applicant is trying to subvert course of justice, that having been settled, any step taken by this court is double jeopardy, that the applicant cannot file this case without the consent of her husband and that of CP Okolo, that none of the applicant's fundamental right was violated, that the respondents are under Police Officers Protection Act, Public Officers Protection Act 2004. Just like the submission in the counter affidavit, counsel repeated in his written address that the police have power to detect and investigate crime, that the investigation cannot be construed to mean breach of fundamental right of such a person, and cited Samuel versus Controller of Prisons, Uyo, Akwa Ibom State, Tukur and Gongola, all supra, that in Saraki, and that in the case of Saraki versus Inspector General of Police, supra, the Supreme Court held that invitation cannot construe to mean arrest, that by rule of professional conduct 2007, it is an offense for a lawyer to fail to advise a client on ADR option. Counsel submitted that this action has been settled by ADR. What I can deduce from these submissions are: 1, whether the suit is caught up by the Public Officers Protection Act 2004. 2, whether the act of settlement done by the parties, by the first respondent, is a bar for any subsequent action by any of the parties to this case. 3, whether the applicant has disclosed any cause of action by this suit. 4, whether the applicant is a member of the Nigerian Police Force who cannot sue without the permission of the Commissioner of Police and the Inspector General of Police, and whether the procedure followed by the applicant in filing this case is in breach of the procedure for filing an action under the Fundamental Right Enforcement Procedure Rules of 2009. By paragraph 7 of the affidavit in support of the preliminary objection, the respondents through the second respondent, who is the deponent, states that all police officers, being public officers, are protected under the Public Officers Protection Act 2004. In paragraph 20, counsel equally submitted that the court lacked text that the equally submits that the court takes judicial notice of Order 2, Rules 1 and 2, Order 3, Rules 1 and 2 of the Fundamental Rights Enforcement Procedure, Rules 2009, and Section 2A of the Public Officers Protection Act, and equally submitted that the applicant has no locus standi to bring this suit against the Commissioner of Police. In paragraph 6 of the counter affidavit, the applicant as deponent states that paragraph 7 is false, while in his address, counsel states that by Order 3 of the Fundamental Right Enforcement Procedure, Rules 2009, Public Officers Protection Act 2004 does not apply to cases of fundamental right, and cited the case of Nigerian Ajib Oil Company Limited versus Dio and others, Supra. The second respondent, who is also a deponent in paragraph 9.9 of the further and better affidavit filed on the 11th of November 2022, states that I and the first and the first respondents are public officers protected by the Public Officers Protection Act, and if any action is not brought within the 3-month prescribed period, such action is abated. Throughout the 2 pages of the written address, counsel did not make any effort to counter the submission of the applicant counsel, rather took the whole time narrating the powers of the police under the act. It is the submission of the applicant counsel that by Order 3 of the Fundamental Rights Enforcement Procedure, Rules 2009, the provision of the Public Officers Protection Act does not apply to cases of fundamental rights. For clarity, let me at this point reproduce Order 3 of the Fundamental Rights Enforcement Procedure, Rules 2009. An application for enforcement of the fundamental right shall not be affected by any limitation statute whatsoever. The Court of Appeal, as per Awotowoye JCA, on pages 45 to 46, paragraph D to B, where the court made it clear that the date of cause of action of court is immaterial, provided it is after the commencement of the 1999 Constitution of the Federal Republic of Nigeria. In the case of Nigerian Ajib Oil Company Limited versus Dio and others. The respondents from all the submissions of the counsel to the objectors, nothing was submitted to the contrary. By the wording, the commencement of the Fundamental Right Enforcement Procedure Rules 2009, the Chief Justice of Nigeria derives his power to make the rules under Section 46, subsection 3 of the 1999 Constitution of the Federal Republic of Nigeria. The Court of Appeal in Nigeria Ajib Oil versus Dio and other Supra state that even if the action commenced before the 1999 Constitution, it is still covered by the rules as long as the case is that of enforcement of fundamental rights. See Order 15, Rule 3 of the Fundamental Right Enforcement Procedure Rules 2009. Based on the submissions of both the counsel to the applicant and that of the respondent in the preliminary objection as summarized above, therefore, I hereby hold that the submission of the counsel to the respondent, who is also the applicant in this suit, and hold that the limitation, that the statute of limitation, that is Public Officers Protection Act, in this case does not apply to cases of fundamental right. I hereby uphold the respondent's counter affidavit to the preliminary objection and resolve this issue in favor of the respondent's applicant in this suit. The second issue as formulated by the court is whether the act of settlement done between the applicant and the second respondent by the first respondent, who is the Commissioner of Police, constitute a bar subsequent subsequent to any action by the parties. The respondent, as applicant, in preliminary objection, particularly paragraph D of the ground of objection, paragraph 2, 3, and 4 of the affidavit in support of the PO. In paragraph 201, counsel submitted in their written address that the applicant husband and the respondents are members of the Nigerian police, and that the second respondent, having been queried, any pronouncement by this court amount to double jeopardy. In paragraph 3 of the counter affidavit, the applicant, as deponent, states that she is not aware of paragraph 4. In the second to the last paragraph of the unnumbered written address, counsel submitted that the second respondent was queried for using his office to infringe on the applicant's right. In their further and better affidavit, particularly in paragraph 3, the deponent made mention of departmental ADR. Again, in paragraph 9 of the further and better affidavit, particularly A, B, C, and D, written as D, and then F, the deponent, particularly in 9G, when properly numbered, the deponent raised issue of double jeopardy. As stated earlier in the written address did not in any way mention any issue of double jeopardy or compliance before suing or filing this case. The issue of getting permission before filing this suit was only mentioned without any law cited, be it statute or a case law. By code of conduct in part 15, Nigerian Police Regulation, section 352 and 353 is to do with the conduct of police officers and not anyone who is not a member of the force. I decided to cite this provision because counsel to the respondent, who is a police officer, did not in any way in his submission in the preliminary objection attempt to put the position clear by statute or case law. On double jeopardy, which the counsel raised in his address, the question one should ask is, what is double jeopardy? The Black's Law Dictionary, second edition, simply states the criminal defendant may not be tried twice for a crime. Then the question is, was the second respondent tried by any court of law? What was the verdict of the court? Administrative discipline cannot be equated to court trial. The submission of the counsel to the respondent is complete misconception of understanding of the word double jeopardy. The police regulation cited above, to my mind, does not cover wives and children of police. And as such, the applicant need not to take permission from anybody to institute an action against the police. I hereby on this resolve the issue in favor of the respondent applicant. On issue 3, as to whether there is any reasonable cause of action and whether the suit is constituted, as constituted, was properly filed, I intend to treat issue 3 and 4 as formulated by the court together. I am in this regard decide to be careful so that I don't go into the merit of the case while dealing with the PO. On locus, counsel to the objector in ground for objection F, G, and H in paragraph B and C, the deponent raised the issue of locus standi. Again, in their written address, counsel cited Modokulu versus Nkendulem, Onibudo versus Abdullahi, and Ategbu versus Oni. The respondent struck applicant in their counter affidavit in paragraph 11 states that her right was infringed by the second applicant. By paragraphs 13, 14, 15, 16, and 17 to their counter affidavit to the main case, the plaintiff's case has failed. By motion on notice of the applicant and the sections of the law cited, particularly Order 2, Rules 1, 2, 3 of the Fundamental Right Enforcement Rules 2009, Section 34.1, 35.1 of the Constitution as amended, Article 5, 6D of the African Charter on the Human and People Rights, laws of the Federation, and the inherent jurisdiction of this code, I agree that the case is properly before the court. I hold that the applicant has, as a citizen of Nigeria, has the right to approach the court under the laws of the land, particularly the constitutional provision. On jurisdiction of the Federal High Court, which the respondent raised in his address, I refer to the case of Extension Publication Limited versus Sunday Oyedepo, 2022 LPE LR 57307 Court of Appeal per NIMPAL JCA on page 35, paragraphs B to E. I respectfully do not agree or subscribe to this submission on the ground that there is nothing in our statute that precludes the Federal High Court from adjudicating on fundamental right matters, because under Section 46 of Section 3 of the Constitution of the Federal Republic of Nigeria as amended, and Order 1, Rule 2 of the Fundamental Right Enforcement Procedure Rules, the word court includes Federal High Courts. Standing on this authority, I hold that the suit is properly before this court, and the court has jurisdiction to hear and determine the suit. Having held that the applicant has locus standi, as in Modokulu versus Nkendili, and the fact that this court has jurisdiction to hear this case, I hereby resolve this issue formulated by the court in favor of the applicant. Having resolved the four issues, all the four issues, that is, including 3 and 4, having been dealt with in 1, I hereby dismiss the preliminary objection of the respondent. Having dismissed the preliminary objection by the respondent, I now go into the case of the applicant and defense of the respondent. The applicant's claim against the second respondent by the application under Order 2, Rule 1, 2, 3 of the Fundamental Right Enforcement Rules 2009, Section 34.1 and 35.1 of the 1999 Constitution of the Federal Republic of Nigeria, and the inherent jurisdiction of this court is for the sum of 5 million for an unlawful arrest, detention, and assault, occasioning harm of the applicant as damages. Earlier on in this judgment, I have reviewed the submission of the parties, which include the application, the affidavit, and the address of the applicant's counsel. I have also reviewed the counter affidavit and the written address with further and better affidavits in reply on point of law by the applicants. The applicant, by paragraph 3 to 8, narrated how the second respondent arrested her for no known reason, threatening to beat her thoroughly, that she was taken to anti-cultism unit of the police at Road Safety Road, Yenabua, that there she was asked to sit on the floor, that there was no complaint against her, that she does not know the second respondent, except that they used to speak on phone, which was given to her by one Sergeant Daniel, that the cell phone is 08069227780. In paragraphs 9 to 13, the applicant as deponent stated that the second respondent beat her to the extent that she became unconscious, that her husband later told her that at a stage she was unconscious and fainted. In paragraph 14 and 15 of the affidavit, the deponent, who is equally the applicant, states that she was denied bail to her husband, who is equally a police officer, by the second respondent, that exhibit B1 is her photograph, while B2 is the medical report from the police clinic. In paragraph 20, the deponent stated that after waiting for some time to the outcome of the investigation as to her offense and reason for her arrest, she wrote a complaint to the Commissioner of Police, as in Exhibit C. That Exhibit D is the evidence of her routine check up at the hospital. That Exhibit A is the petition to the Commissioner of Police by her lawyer. In their counter affidavit, the second respondent stated that he is deposing to the affidavit with permission of the first respondent, who is the Commissioner of Police, as in paragraph 4. In paragraph 9, the second respondent as deponent denied paragraph 4 to 26 of the applicant counterclaim, which I found it strange, being the respondent replying himself. In paragraph 11 of the counter affidavit, the second respondent denied paragraph 5 without stating the affidavit he is denying. But what I deduce is that going forward, he stated that he invited the applicant to his office to know why he was not paid his contribution, which led to the altercation between him and the applicant. That in the course of the altercation, the applicant poked his eyes, as in Exhibit CP1 and CP2 respectively. In paragraph 13, the deponent states that he was queried and warned, as in Exhibit CP4 and CP5. In paragraph 14, the deponent states that since the applicant is a police officer by reason of her husband, who is a police officer, the matter was finally settled by the first respondent. In paragraph 22A to G, the deponent raised several issues with regard to the case at hand and whether this court has jurisdiction to hear this case. By affidavit, the applicant tried to justify this case and denying the respondent, by affidavit, the applicant tried to justify this case and denying assaulting the second deponent, particularly CP1 and CP2. That by exhibit CP1 to CP4, there is breach of our fundamental right. That is why the second respondent was queried and warned by letter dated 30th of April 2021 and 10th of June 2021. In their further and better affidavits dated and filed on the 11th of November 2022, the respondent stated, particularly in paragraph 5 and 6, that the applicant was never arrested, detained, or investigated. Issues raised by the affidavit and the addresses of both the applicant and the respondent in this suit can be summarized in the following: whether there was arrest of the applicant by the second respondent and whether there was abuse of power in this regard, whether this court can adjudicate in this case, adjudicate this suit, whether the police acts, whether by the police acts the applicant can file this case being a wife of a police officer. 4, whether this case is personal or official based on the standing of the respondent as a police officer. On issue 1, as formulated, the applicant by their claim is praying for declaration that the actual arrest, detention, harassment, and assault of the applicant by the second respondent, denying her access to her family members and solicitors, is a breach of her fundamental right as provided for by section 31, 34.1 and 35.1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Article 5, 6, B and D of the African Charter on Human and People's Rights, Laws of the Federation of Nigeria 2004, Section 34.1 of the 1999 Constitution of Nigeria as amended states, every individual is entitled to respect for his dignity, for the dignity of his person, and accordingly, A, no person should be held subjected to torture or inhuman or degrading treatment. B, no person should be held in slavery or servitude. And C, no person should be required to perform forced or compulsory labor. Section 35, subsection 1 states, every person should be entitled to his personal liberty, and no person should be deprived of such liberty, save in the following cases, and in accordance with the procedure permitted by law. The exceptions are stated in A to F of the subsection. The exceptions are stated in A to F of the subsection to this section. The ground on which the relief is being sought is that the second respondent, then at the anti-cultism unit of the Nigerian police, did arrest the applicant to his office at the road safety road, Yenogua, and physically assaulted her by beating her and pushing her to the ground and matching her with verbal words that her husband, Mr. Daniel, is his junior and will do nothing. That the second respondent also denied her access to her family and family members and solicitors. That this action is in contravention to section 35.1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Article 5 of the African Charter on Human and People's Rights, that the applicant by Section 36(5) of the 1999 Constitution as amended is presumed innocent until proved otherwise. The applicant by paragraphs 4 to 16 of the affidavit in support narrated the whole scenario of what transpired between her and the second respondent. By paragraph 6, she was taken to anti-cultism unit of the police. By paragraph 9, there was no formal complaint. By paragraph 10, 11, and 12, the applicant stated that she was beaten and her husband and her phone was seized. In paragraph 14, according to the applicant, she was denied bail to her husband by the second respondent. By paragraph 15, it was the intervention of the PPRO that made it possible for the second respondent to release her to be taken to hospital. Counsel, in his address on this issue, submitted in 3.1 of the address that enforcement of fundamental rights are peculiar and special in nature, and to be decided on the affidavit and counter affidavit, and cited the case of Afribank Nigeria Limited versus Adigo Supra at pages 2026 to 2027. That the court, in application of this nature, is to rely on facts placed before the court, and cited Fortis Microfinance versus Amefula and others, reported in 2021 LPELR 5270780, pages 40 to 41, paragraph F to C. By counter affidavit in paragraph 9, the second respondent denied paragraph 4 to 26 of the applicant. By paragraph 10, the second respondent denied arresting, detaining, or investigating the applicant. In paragraph 11, the deponent as second respondent stated that he invited informally the applicant to inquire from her to know why she disappointed him in not paying to the second respondent money that they usually contribute every month when it was his turn to collect the contribution, and that from there was altercation, which led to the applicant poking into the eyes of the second respondent that led him going to led him going to hospital as in exhibit CP3, CP4, and CP5. The question here is whether or not the applicant was invited and on whose complaint. By paragraph 11, 12, 13, 14, 15, 16, and 17, the respondent only tried to justify the invitation. The second respondent only tried to justify the invitation of the applicant to his office. In her further affidavit, in paragraph 4, 5, 6, and 7, applicant stated that she was not informed of the reason for her invitation to the office of the second respondent. That exhibit CP1 to CP4 is clear evidence that there was breach of the right of the applicant. Counsel to the applicant urged the court to discountenance the respondent's argument and held that the provisions cited by the applicant are alien and unconnected. In their further and better affidavit, the deponent as second respondent in paragraph 6 states that paragraphs 3, 4, and 5 of the applicant affidavit are false, that paragraph 8, 9, and 10 are denied, as well as paragraph 6 and 7 of the further affidavit of the applicant. Counsel in paragraph 05 of the address cited Saraki versus IGP. I must state here that in Saraki's case, it was an invitation, while in this case, there was invitation, and the invitation was honored by the applicants. In 2.0 of the address, counsel to the respondent, by his submission, states that by allowing herself to go into ADR, the applicant has lost locus to bring this action. I entirely disagree with this submission, in the sense that there is nothing like an ADR center that was attended to by the applicant and the second respondent. The ADR I know in Bayelsa State is at the State High Court, which has been gazetted. And if there was any ADR, the record of proceeding of the outcome has not been presented before this court, in this case in particular. In paragraph 8 of the further and better affidavit, the deponent states that he authorized his boys to take the applicant out of his office. The applicant never walked into the office of the second respondent by herself, but in invitation. And why did the second respondent ask his boys, which I know as a fact that they are policemen, to take her out? And an invitation, whether formal or informal, as long as it's honored by the invitee, is conclusive that there was invitation. Exhibit CP1 and CP2, which are query dated 30th April 2021 and replied by the second respondent on the 6th of May 2022, and warning letter dated 10th of June 2021, which in paragraph 3, Council state in paragraph 3 of the letter states that you are hereby seriously warned to amend in your character and behavior if you want to continue in your career in the Nigerian police force. Be warned seriously shows that the police force as an organization is showing displeasure in what transpired between the second respondent and the applicant. On exhibit OP3, CP3, CP4, and CP5, I cannot imagine the applicant assaulting the second respondent in his office when he stated in his affidavit that his boys took the applicant out of his office. Where were they when the applicant was being assaulted? I refuse to believe this story, this side of the story. Having carefully gone through the affidavit, the laws, and the authorities cited, I resolve issue 1 formulated by the court in favor of the applicant and hold that the applicant was invited, detained, and tortured by the second respondent in his office as AD anti-cultism section of the Nigerian police in Yenagoa. I also hold that the second respondent abused his office in inviting and beating the applicant in his office on issue bordered on monthly contribution in violation of section 353 of the Nigerian police regulation, which disallow personal position, public position for his private advantage and allowing private interest to come into conflict with his public duty. I resolve issue 1 therefore in favor of the applicant. On issue 2 and 3 formulated, I intend to take them as one. The issue is whether the applicant can file this case being a wife of a police officer, and whether as a police officer's wife, whether the applicant can file this case as a wife of a police officer. By paragraph 10 and 101, it is the submission of the counsel to the respondents that section 98 of the Police Act, the applicant has no locus. Section 98 is very clear as to anyone who assaults a police officer on his duty or aids or incite any other person to assault or obstruct, being a provision that provides for punishment, the applicant should have been charged, but rather the police as an organization in this case queried after reply to the query, warned the second respondent. On this, I refer to exhibit DCP2, which is the query. Reply to the query by the second respondent and warning letter. It is the contention of the applicant through her counsel in paragraphs 3.1 and 3.2 of the address that the case of AfriBank Nigeria PLC and Adegun Supra, Fortis versus Microfinance Bank, Amefula Bank versus Amefula and others, there was breach of fundamental rights of the applicant by the action of the second respondent, and this gives her the right to file this suit and claim for damages as per the claim of the applicant. The respondent through their counsel also cited Gani Oladiji versus IGP, Nwosu versus Imo Environmental Sanitation Authority in his contention that police officers cannot be sued in the first cannot be sued in the first cannot be sued as the first respondent in his own official capacity. In reply, the applicant in her further and better affidavit in paragraph 5 states that if the business was civil, she wouldn't have been arrested. Counsel to the applicant in paragraph 1 on page 2 of the unnumbered written address cited Samuel versus Controller of Prisons, Akwa states, and state that the argument of the respondent is misplaced, that the Police Act cannot avail the second respondent because he used his office in infringing the right of the applicant. On this, I hold that having used his office to invite the applicant and having also known that by chain of command, the second respondent is under the command of the first respondent, the applicant is right in joining the first respondent. And I hold that nothing stopped the applicant from filing this case. And whatever part of the police regulation, the regulation I referring does not have any effect on the applicant who is not a policewoman. By virtue of her marrying a policeman, the regulation pertaining police force does not affect her in any way. I resolve this issue in favor of the applicant and hold that the applicant can file this case. As to whether the case is personal or official, I do not need to dwell much on this, having in this judgment stated that the applicant was invited to the office of the second respondent and assaulted, and having engaged the services of a police counsel who is being paid salary by the police, it clearly shows that the act is official. Otherwise, the prosecuting counsel, the police counsel lawyer cannot appear for an individual. On the proof required by law, the applicant before this court, I am in agreement with AfriBank Nigeria Limited versus Adigun, where the court, as per Ogunwumi JCA on pages 20 to 21, paragraph BTA, as reported in 2008, LPELR 3634 CA, states in part that what the court looks at in a case of this nature is the affidavit of the applicant. As stated earlier, paragraph 6 to 21 is very clear. Relying on the case of Diamond Bank versus Opara, 2018 LPELR 43900, as per Bagge JSC on pages 30 to 33, paragraph 6b, I hold here that the applicant has proof before this court a case of breach of fundamental right as enshrined in section 34.1 and 35.1 of the Constitution of the Federal Republic of Nigeria. And having proved such, I hereby award a damage of 500,000 against the second respondent in favor of the applicant. This is the judgment of this court.
As the court please, my lord, we are very grateful for the ruling of this court and the reasoning. We pray that the message be sent across to other police officers so that they may serve as deterrent. My lord, we are most grateful.
Thank you.
My lord, we will explore all the evidence for us. Thank you, my
Yes.
lord.
Thank you. I will send the file and the judgment within 1 week. Everything will be in Yanagua. Those who want to try it upstairs, they can try their best.
As the court please.
Thank you, my lord. My lord, we are amenable. Proceed.
Thank you so much.
My lord, the best, sir.
Lord, we are
Thank
grateful for the
Thank
diligence.
you. Bye-bye. Thank you.
Right, sir.
Okay. Yes.
My lord, wish you well.
Okay.
500